Swayam Prabha. Digital India. Educated India.
Hello viewers, welcome in today's talk on jurisprudence. I am Dr. Simranjeet Kaur Gill, Professor in Laws, City University, Ludhiana. Today we shall talk about rule of law by Joseph Raz's application in India. In introductory remarks, rule of law is not a new concept. This idea was the first recorded to have been conceived by Aristotle way back in 350 BC. His work on the topic, in fact, is still considered influential. The trend continued with the other eminent thinkers such as Sir John Forcastle, John Locke, Montesquieu, etc., adding their thoughts and contribution to the development of the concept. The formal origin of the word is attributed to Sir Edward Coke and is derived from the French phrase la principe de legality, which means the principle of legality in India. The concept has been traced as far as back as the Upanishads, where it states that law is the king of kings. It's more powerful and rigid than the kings, and there's nothing higher than the law. The weak shall triumph over the strong, and justice shall prevail by its powers. This theory has further been exposed by the Indian thinkers such as Chanakya, as well as who maintain that king should be governed by law. The credit for developing the modern theory of rule of law, however, is given to British jurist A.V. Dicey. He expounded the theory in his book called Study of Law and Constitution. Dicey's theory was based on three principles, commonly called the pillars: supremacy of law, equality before law, and predominance of legal spirit. His ideas persist even today, though modern points of view have since emerged. Inherent in this theory is the idea that the British way of governance is perfect example of rule of law. However, Dicey was factually incorrect in these circumstances, since he completely ignored the constitutional maxim "the king can do no wrong," which effectively granted absolute privilege to the entire government by virtue of the crown. He also ignored the statutes that granted discretionary powers to the government and outright ignored the growth of administrative law in Britain, which he claimed was against rule of law. All in all, Dicey's theory was the reason the development of administrative law in the country began late in the day. Joseph Raz is an Israeli legal, moral and political philosopher. He is renowned for his conception of perfectionist liberalism and is also one of the most prominent advocates of legal positivism. He was a professor of legal philosophy at the University of Oxford, Raz, and is now a part-time professor of law at Columbia University Law School at King's College, London. He received prestigious Tank Prize for Rule of Law in 2018. Raz's theory of rule of law. Joseph Raz gave his theory of rule of law in 1979 through his book The Authority of Law. Essays on Law and Morality. He draws heavily from F. A. Hayek's work and analyzes the concept of law and morality in a similar fashion. According to him, Hayek has formulated the most powerful ideal of rule of law, that is, stripped of all technicalities. This means that government in all its action is bound by rules fixed and announced beforehand, rules which make it possible to foresee with the fair certainty how the authority will use its courtship power in the given circumstances, and to plan one's individual affairs on the basis of this knowledge. Raz's purpose, as he states in his book, is to analyze the ideal of the rule of law in the spirit of Hayek's quoted statement and to show why some of the conclusions he drew from it cannot be thus supported. In his work, Raz has enumerated some basic principles that emerge from the study of the idea of rule of law. His 8 principles may be enumerated as: all laws should be prospective, open and clear. Laws should be relatively stable. The making of the particular laws, particular legal orders should be guided by open, stable, clear and general rules. The independence of the judiciary must be granted. The principle of natural justice must be observed. The court should have review powers over the implementations of other principles. The courts should be easily accessible. The discretion of the crime preventing agencies should not be allowed to pervert the law. Application of the theory: all laws should be prospective, open and clear. A law should not have retrospective action. One cannot be guided by a retroactive law as it did not exist at the time of the action. This specially applies to the criminal substantive law. Occasionally, it is known beforehand that a certain law will be enacted retrospectively. In such a situation, it would not be repugnant to the rule of law. The common law principle of ignorantia juris non excusat make it legal necessary for every person within India to have knowledge of the laws of the land. Indeed, the courts do not consider ignorance of the law as a valid defense. Therefore, the duty falls upon the state to notify the public of any enacted legislation. In India, a law is considered to be enacted once it is passed by Parliament and published in the official gazette. The law must be open for all, easily accessible and adequately publicized. For the same reason, its meaning must also be clear. An ambiguous, vague, obscure or imprecise law is likely to mislead or confuse at least some of those who read it. For example, any and all the amendments to the substantive criminal law must have prospective action. This is so that an accused will not be suffer increased punishment because of a change which is occurred after he had committed the crime. However, the same does not apply to the procedural criminal law. For the most part, a recent case sheds some light on the subject. In Mallikarjun v. State of Karnataka, the applicant was aggrieved by the fact that his appeal as a victim was not allowed by the High Court on the ground that offence occurred prior to 31st December 2009, and the provision came into effect only from the 1st January 2010. It was held that right of appeal accrues at the time of delivery of the judgment, and hence the appeal should be allowed. Laws should be relatively stable for formal conceptions. Having law is valuable because regardless of the content of the law, legal rules that are properly framed, administered and educated enable predictability of legal outcomes and people's reliance on the law, and hence serve people's autonomy's interest. The relatively stability of the law directly ties in with the procedures for the amendment of the law. The easier the process, the more likely is to be amended. For example, like any other constitution, the Constitution of India also provides for its amendment in order to adjust itself to the changing conditions and needs. However, the procedure laid down for its amendment is neither as easy as in Britain nor as difficult as that of USA. That is, the Indian Constitution is neither flexible nor rigid, but rather a fusion of both. Article 368 in Part 20 of the Indian Constitution describes the powers of the Parliament to amend the Constitution and lays down the requisite procedure. It states that Parliament may, in exercise of its constituent powers, amend by way of addition, variation or repeal any provision of the Constitution in accordance with the procedure so laid down for the purpose. However, the Parliament cannot erode the basic structure of the Constitution by amending provision which form part of it. The making of a particular laws, particular legal orders should be guided by open, stable, clear and general rules. There must exist some stable general rules to guide the making of laws. According to Ras, conformity with the rule of law is a matter of a degree. It is morally valuable because in serving the values of predictability and certainty, it reduces opportunities for arbitrary state actions, and in doing so, it is capable of expressing respect for human dignity by taking seriously people's ability to plan their lives. He also argues that particular laws must be subject to the general laws. However, in the Indian scenario, it is settled principle of law that the special law will prevail over the general law. The scope of the code of the civil procedure, for instance, is such that where there is a conflict between the code and a special law, the latter shall prevail. The code being a general law, where the special law is silent on a particular matter the code applies, but consistently with the special enactment. For example, a recent case which dealt with the IT Act and IPC upheld this principle. In this case, the issue was whether the appellant who has been discharged under Section 67 of the IT Act could be proceeded under Section 292 of the Indian Penal Code. The apex court held that High Court has erred in its reasoning that though charge has not been made under Section 67 of the IT Act, yet appellant could be proceeded under Section 292 of Indian Penal Code. The proceedings as such instituted against the appellant were quashed. The independence of the judiciary must be granted. The concept of the judicial independence is much more complicated and ambiguous than it seems. Judicial independence can be generally defined in the terms of freedom, responsibility to the rule based on the facts and the law, and thus freedom from undue external restraints. This definition of judicial independence can accommodate both common law and civil law traditions. Independence plays an important role in the system of governance, but it is reasonably compromised to some degree by the concern for judicial accountability. Independence of the judiciary is a salient feature of Constitution of India. This organ has often been named the custodian of the citizens' rights, and in a federal system such as India, it also acts as the balance wheel by settling intergovernmental issues. Separation of executive from the judiciary is also dealt with Article 50, which is directive principle of state policy. For example, the basic principle of the right to a fair trial is that proceedings in any criminal case are to be conducted by a competent, independent and impartial court. In a criminal trial, offences are said to occur against the state rather than an individual. As such, the state functions as the prosecuting party and the investigating agency. The police is but an agency of the state. It is therefore important that judiciary is not burdened with executive influence and control, whether direct or indirect, and is able to function in an impartial and fair manner. The principles of natural justice must be observed. Natural justice is also known as a common sense justice. Rules of the natural justice are not in a codified form. These principles are embedded or ingrained in the conscience of the human beings. It supplies the omissions made in codified law and helps in the administration of justice. Natural justice is not only confined to fairness, it will take any shade and color based on the context. Thus, natural justice, apart from fairness, also implies reasonableness, equity, equality. They are neither cast in a rigid mold, nor can they be put in the legal straitjacket. These principles of the nature are written in the heart of mankind. They are imputable, inviolable and inalienable. The principle of natural justice basically are of two kinds. No one should be condemned unheard or de ultram partem. No one should be judged in his case, nemo judex in causa sua. The principles of natural justice are the fundamental aspect of the Indian Constitution. Though they flow from Article 14 of the Indian Constitution, the Supreme Court has held that these principles would exist even in the absence of such a provision. For example, in India, the principles of natural justice are embedded in the procedural law. One of the primary tenets for conducting a fair trial is compliance with the principles of natural justice. Another example is that preventive detention. According to Article 22, subclause 5, the detainee is to be afforded the earliest opportunity of making a representation against the order of detention. The courts should have review powers over the implementation of the other principles. Judicial review is the power of the judiciary to interpret the Constitution and declare any law or order of the legislature and executive void, if it finds them in conflict with the Constitution of India. A democracy without some form of judicial review is considered deficient. Although the spread of judicial review of administrative law predates and does not track the same historicity of the judicial review of legislation, the nexus between the two and their cross fertilization has become evident. The European Court of Justice tersely and compellingly defined a central aspect of the very rule of law as requiring any legal act affecting the statutes of any legal actor as being potentially subject to review by a court. Where judicial review of an administration once obsessed with the issue of intra and ultra vires and a weak form of rationality as a criteria for substantive review. Today, both versions have placed proportionality as the central tool and characteristic of review. Judicial review has two important functions: legitimizing government action and protecting the Constitution against undue encroachment by the government. It is a part of the basic structure of the Constitution of India. For example, the biggest example of the judicial review in India is the case of I.C. Golaknath versus State of Punjab, wherein an 11-judge bench of the Apex Court by majority of 6-5 reversed its earlier decision in Sajan Singh and Shankari Prasad and declared that Parliament under Article 368 of Indian Constitution has no power to take away or abridge the fundamental rights contained in Part 2 of the Indian Constitutions. The courts should be easily accessible. Everyone should be able to assess the judicial machinery of the country as and when necessary. The central position of the courts within this machinery makes their easy access of paramount importance. Long delays, excessive costs, etc. may effectively turn the most enlightened law to a dead letter and frustrate one's ability effectively to guide oneself by the law. right to assess justice and right to speedy trial are both fundamental rights under Article 14 and 21 of the Constitution of India. Legal aid is also one of the prominent methods through which attempts are being made to increase the accessibility of the layman to the courts. For example, Order 33 of the Civil Procedure Code is essentially a provision for providing legal aid to those who are unable to assess the justice due to the high litigation cost. Legal aid by itself is a topic for the debate and deliberations in India. Its need being recognized now more than ever. This provision under the Code also protects natural justice by enabling all citizens, irrespective of their caste, creed, occupation, economic background, to stake claims in the court of law. The discretion of the crime preventing agencies should not be allowed to pervert the law. It is not just the court which through judicial activism or otherwise may pervert the law. The actions of the police and the prosecuting agencies can also have a similar effect. For instance, allowing the prosecution to decide which cases to prosecute or which people to prosecute is highly unfair and goes against one of the very basic tenets of the society. Today, the right to equality, it is of course a well settled principle that discretion leads to arbitrariness, and arbitrariness stabs at the very heart of Article 14. For example, when any offence has been committed, the police is bound by the law to register the case by means of first information report, which we also called FIR, under section 154 of the Code of Criminal Procedure. In case the police officer in charge refuses to register an FIR, the person so aggrieved may send the relevant information to the superintendent of the police, who will then proceed as needed. So, in concluding remarks, I would submit that rule of law has undergone many trials in India. The shape and the form that it has today is the product of many decisions taken by learned men over the years, and the path has not been straight. This particular lecture has analyzed the formal concept of rule of law as given by the Joseph Raz. His 8 principles, virtues have been examined in the light of the Indian scenario. What emerged is the fact that India does, for the most part, adhere to the Raz ideal, but somewhere the unique Indian character has shown through. The country has adapted and adopted the principle to suit its own purposes, forming a mixture that is unique for better or worse. So, this was all about today's talk. Thank you so much for watching this program.